A name was spoken in a federal courtroom 48 hours ago that changed everything. Not a witness, not a defendant, not someone you'd expect. And the moment it entered the official record, phones started buzzing across Washington. Attorneys went silent. Staffers started scrubbing documents. Because this name connects directly to the highest levels of power, and it just became evidence in an active federal investigation. Here's what they're not telling you about what just happened. Let me be very clear about something. When a federal prosecutor allows a specific name to be entered into open court testimony, that is not an accident. That is a strategic decision made at the highest levels of the Department of Justice. And when that name belongs to someone inside the political apparatus, someone with direct access to decision-making authority, you're looking at the beginning of a chain reaction. What we saw this week wasn't just courtroom drama. It was a signal. The filing came out of the U.S. District Court for the District of Columbia. The proceeding itself seemed routine, a pretrial motion hearing in a case most legal observers thought had already been mapped out. Standard procedure. Nothing to see here, except one of the cooperating witnesses under cross-examination was asked a very specific question about communication protocols during a critical 48-hour window in late 2024. And in answering that question, the witness identified someone by name, someone who was allegedly briefed on actions that are now the subject of federal criminal scrutiny. Think about this for a second. Federal prosecutors don't let witnesses name names in open court unless they've already corroborated that testimony, unless they've got the receipts, emails, signal messages, testimony from other witnesses, phone records. This wasn't a slip. This was deliberate exposure. Now, the media is focused on the surface level story. Who said what? Partisan reactions, political fallout. But from a prosecutor's perspective, that's all noise. What matters is this. The moment that name entered the federal record, it became a breadcrumb. And breadcrumbs lead to warrants. Warrants lead to subpoenas. Subpoenas lead to more witnesses. More witnesses lead to immunity deals or indictments. This is how federal cases expand. Let me tell you what the public doesn't understand about DOJ investigations at this level. The prosecutors running these cases, the line attorneys, the supervisors, the front office at Main Justice, they move slowly, methodically. They don't chase headlines. They build evidentiary chains. And when they allow a name like this to surface publicly, it means they've already done the background work. They've already secured testimony. They've already gamed out the next 5 moves. So when you hear pundits say, this came out of nowhere, what they're really saying is, we weren't paying attention. But the defense attorneys were paying attention. The moment that name hit the transcript, you can guarantee that lawyers across D.C. started making calls, checking whether their clients had any contact with this individual, reviewing privilege logs, preparing damage control, because they know what's coming next. Here's what they're not telling you. The witness who named this individual isn't just any cooperator. This is someone who flipped early, someone who took a deal before the walls closed in, and that matters because early cooperators get the best terms. They also tend to be the most valuable because they were inside the room when decisions were being made. Now, I can't tell you the specific name that was spoken because doing so could interfere with the integrity of an ongoing case, and frankly, the transcripts are still being reviewed. But I can tell you the profile. This is someone with institutional access, someone who would have been part of closed-door strategy sessions, someone whose calendar, whose emails, whose call logs would be devastating if they contradicted the official narrative that's been presented to Congress and the public. And here's the prosecutorial insight most people miss. When you're building a conspiracy case or an obstruction case or a case involving abuse of power, you don't start at the top. You start at the outer ring. You flip the people who were in the hallway, the schedulers, the junior staffers, the people who saw the emails but didn't send them. Then you move inward, ring by ring, name by name. And every time a new name surfaces in court, you're watching that ring tighten. From a prosecutor's perspective, this is textbook. You create pressure. You let people know their names are being discussed. You let them understand that their silence is noted, and then you wait. Because here's the thing about federal exposure. It doesn't go away. It compounds. The longer you wait, the worse your options become. The more other people talk, the less valuable your cooperation is. This is how you break institutional omerta. Let me walk you through the legal architecture of what we're seeing. Under federal conspiracy statutes, 18, USC, paragraph 371, for example, the government doesn't need to prove that everyone involved knew every detail of a scheme. They just need to prove that participants knowingly joined a common plan and took steps to advance it. That means if this individual whose name was just spoken participated in meetings, sent emails, made calls, or took any action that furthered an unlawful objective, even if they claim they didn't understand the full scope, they can be charged as part of the conspiracy. Now, compare this to what we saw in the Mueller investigation. Remember how the special counsel's office built cases? They started with process crimes, false statements, obstruction. Then they used those convictions to apply pressure upward. They identified communication nodes, people who were in contact with multiple targets, and they squeezed. That's exactly what's happening here. We've already seen subpoenas issued to communication providers. We've seen immunity grants to lower level actors. We've seen plea agreements that require full and truthful cooperation with ongoing investigations. And now we're seeing names. Here's what that tells me as a former federal prosecutor. The government has moved beyond the evidence gathering phase. They're now in the leverage phase. They're letting targets know through public court filings and testimony that the net is tightening. And this individual whose name was just entered into the record, they now face a choice. They can cooperate, get out in front of this, provide testimony, potentially secure a non-prosecution agreement if they move fast and offer substantial value. Or they can stay silent, risk indictment, risk a trial, risk a conviction that carries serious time. There's no third option here. Now, let me give you a historical comparison. During the Watergate investigation, prosecutors used a technique called speaking indictments. These were charging documents that included far more detail than legally required, names, dates, conversations, specifically to send a message to other potential targets. The message was simple. We know what happened. We have the evidence. You have a limited window to get on the right side of this. What we're seeing now is a modern version of that strategy. By allowing this name to surface in open court, prosecutors are effectively saying, if you were in those rooms, if you were part of those conversations, your name is next. Pay attention to this next part. In federal practice, once a name appears in connection with criminal conduct, even if that person isn't charged, they become what we call a subject of the investigation, not a target yet, not just a witness. A subject. That means prosecutors believe they may have committed a crime, but they haven't yet decided whether to charge. And that status can change overnight. So what does this mean for democracy, for accountability, for the rule of law? Let me frame this clearly. What we're watching is a test of whether our institutions can hold powerful actors accountable when those actors have spent years building systems to insulate themselves from consequences. Think about the broader pattern. Over the past several years, we've seen a systematic erosion of norms around compliance, around cooperation with lawful oversight, around respect for subpoenas and court orders. We've seen witnesses refuse to testify. We've seen documents withheld or destroyed. We've seen privilege claims asserted in ways that would have been unthinkable a decade ago. And the question has always been, what happens when the system finally pushes back? This is what it looks like. When a federal court compels testimony and a witness names a high-level actor, that's the system asserting itself. That's accountability, breaking through the layers of protection. But here's the danger. If this investigation stalls, if political pressure mounts, if resources are cut, if leadership at DOJ changes and priorities shift, then this moment becomes just another near miss, another example of power evading consequences. And that sets a precedent. It tells future actors borders, you can push the boundaries, you can test the system, because ultimately, if you have enough institutional backing, you'll walk away. That's not sustainable for a democracy. From a prosecutor's perspective, this case isn't just about what happened in 2024. It's about whether the United States has a functional system of justice that applies to everyone, or whether we've crossed into a two-tiered reality where proximity to power grants immunity. And right now, we're at the inflection point. The investigators are doing their job. They're building cases. They're securing testimony. They're creating the evidentiary record that could lead to accountability. But investigation is only half the equation. The other half is prosecution. And prosecution requires political will. It requires leadership at the Department of Justice that will authorize charges even when those charges are inconvenient, even when they generate backlash, even when they create political firestorms. History will judge what happens next. So where does this leave us? A name was spoken, a record was made, the legal gears are turning, but the outcome isn't predetermined. What happens in the next 60 to 90 days will determine whether this moment was the beginning of accountability or just another chapter in institutional failure. Watch the court filings, watch for additional cooperating witnesses, watch for immunity grants and plea agreements, because each one is a signal about where this investigation is headed. And if you understand what these signals mean, if you can read the legal landscape the way prosecutors do, then you won't be surprised by what comes next. You'll be prepared. Stay informed. More accountability and truth coming.